Welcome back to The Mind of Money with Douglas Lodmell. Howard, we left off, and I want to hit the biggie. I mean, this might be the biggest question that we talk about today, fraudulent conveyance.
Right.
I mean, I get so many calls, so much misunderstanding about what this means. So how do you deal with it?
Well, this is actually part of the course I teach at the University of Miami School of Law. I go through at least one class on fraudulent conveyance, which I don't know if it's even taught anywhere else.
Yeah.
In Florida, we have the Uniform Fraudulent Transfer Act.
Right.
A fraudulent transfer or a fraudulent conveyance is a transfer made for little or no consideration, meaning you didn't get anything in return,
Right.
okay, with the intent to hinder, delay, or defeat the claim of a creditor.
Right.
Okay. The fact that the word fraud is part of fraudulent scares a lot of people.
That's right.
Okay. Okay, because attorneys, by our code of ethics, are not allowed to assist a client in committing fraud.
Fraud, yeah.
But the Florida Supreme Court, for example, and also in New York, a pretty liberal state,
Yeah.
have held that you can't be, if you assist somebody in structuring something that turns out to be a fraudulent transfer, you can't be sued for damages.
Right.
And Utah, for example, in their alleged asset protection trust laws, provides that the attorney who helps a client structure something that turns out to be a fraudulent transfer can't be sued.
Right.
So that's the attitude, at least in these jurisdictions. Okay. So a fraudulent transfer is typically not a crime. Okay.
Right.
It is what's called a supplemental proceeding.
Yeah.
Someone sues you. They get a judgment against you, then they proceed to find out what assets you have and what assets you've transferred for the last 4 years usually. And if you've made transfers for little or no consideration in the last 4 years, the judgment creditor will ask the court to undo those transfers because they were fraudulent conveyances or fraudulent
Right.
transfers.
The remedy is to just
Undo
bring it back.
Yeah,
Undo it.
Exactly.
Yeah.
And the reason the offshore trust is protective in this regard is that in order to be able to undo a transfer, the court has to have the power to tell the person that you transferred the asset to give it back.
Right.
And so the court in the United States does not have the power to tell the offshore trustee in the Cook Islands what to do. That's why the Asset Protection Trust works. It's just that simple.
Right.
No power.
Right, right. And here's the thing I hear all the time. I don't want to do anything wrong, and I don't want to do anything that is going to get me thrown in jail.
Okay. Let me just go one step further and compare fraud with fraudulent conveyance. I've just given just given the definition to the audience of a fraudulent conveyance.
Right.
Fraud is defined in Black's Law Dictionary, which all law students have to buy.
Yep.
Okay. Fraud is defined as an intentional misrepresentation of a material fact to induce someone to act or refrain from acting to their detriment.
Right.
And that is usually a crime.
Yeah.
Okay.
Yeah. Fraud is the biggie.
Right. And it's an entire, if you look at those two definitions, it's clear that they're entirely different.
Right.
One is a transfer with the intent to hinder, delay, or defeat the claim of a creditor. The other is an intentional misrepresentation to get somebody to do something that's going to hurt them.
Right.
Okay?
Right.
Very clearly two different things.
Well, and there's also fraudulent conveyance is a mental intent. In other words, a state of mind. So the court has to look into your mind and say, what were you thinking about when you made that transfer?
Right.
So what that means is there's a whole bunch of factors that we have to look at.
Right.
If a client has, for example, a potential creditor, but there is no creditor, well then I feel very comfortable taking their assets and protecting them because there's no creditor there.
Right.
On the other hand, if a client has a creditor and they owe $200,000, but they have $5 million, we're still protecting all their assets because we're in a situation where we're not going to be making them insolvent.
Right.
At the same time, if you owe $1 million and you have a present direct creditor and there's $1 million there, and you have $2 million and $1 million of it is liquid and $1 million of it is in really difficult, stinky assets, you're under no obligation to keep the liquid part there to hand to your creditor.
You increase your leverage by protecting the liquid asset and leaving the less desirable immovable or stinky asset, as you put it, out there increases your bargaining chip.
Right. So you combine all these factors, and of course, anytime it happens to me, I do a full analysis, and I really say, okay, can we do it? And if the answer is yes, well then, we're going to do it as strong and as hard as we possibly can, and we're not going to worry that we're going to get thrown into jail.
Right.
Which maybe brings up the next biggest question is,
will I go to jail?
Will I go to jail? Yeah.
Okay. Well, there actually have been 2 cases, to my knowledge, where a person who set up an offshore trust has been incarcerated for civil contempt.
Right.
Okay. And one was called the Anderson case.
Yeah.
This was back in the late 90s.
Yeah. Big asset protection case.
Right.
Yeah.
And in that case, Mr. and Mrs. Anderson were co-trustees with the offshore trustee.
Right.
And they were also the protectors of the trust.
Right.
As protectors, they had complete control of the trust.
Yeah, as both roles.
Okay, so their trust provided that when they were ordered by a court to do something, they were automatically removed as trustees, but not as protectors.
Right.
So they argued to the court that since they were removed as trustees, now they didn't have the power to bring the assets back. Okay, but the court, like any person, could see that as protectors, they still really had the power.
Right.
And so they were incarcerated for civil contempt properly.
Not to mention that these guys were really created a Ponzi scheme. They were a little Bernie Madoff, and the whole thing was really stinky from the beginning.
Right.
I mean, this was not sympathetic people, and the court wanted to make a point. We're dealing with the FTC in this case. I mean, it was kind of all the possible bad facts that you could ever come up with.
Those are the ones that make the headlines.
Yeah.
Okay, and the other case was...
Which, by the way, they spent how much time in jail?
They spent, I don't know, 6 months or something. Not that long. But it might have seemed long.
Just to set the record straight, they did everything wrong, everything. They spent 6 months in jail, and they ended up really settling, as far as we know, with the FTC for pennies on the dollar.
Right, the FTC did not get what they wanted.
They did not get it, right? So it still worked is the point.
Right.
Yeah.
When people say, does this work? This is a good point, too, just a little segue here. The definition of does the Asset Protection Trust work is, did you come out better having had the Asset Protection Trust than you would have come out if you didn't have it? And I would say in every case you'll come out better.
Absolutely.
Okay. Yeah. So that's, it works.
Yeah.
The other thing people are concerned about is this contempt, which we just mentioned, the Anderson case. The other sort of big case, if you will, came from South Florida, and it's called the Lawrence case.
Yes.
And very, very misunderstood case.
Yeah, very misunderstood.
Okay. First of all, I knew the lawyer who prepared the trust in this case. I didn't know it at the time, but I found out later that I knew the guy.
Okay.
And this was the first trust he ever did.
Oh.
Okay, that's number one. And that was evidenced by the fact that provisions kept getting added to the trust.
Oh, yeah.
Getting added to the
trust. You didn't
trust.
get it quite
month
right
by
the
month.
first time.
You didn't get it right the first time.
Yeah.
But what happened was, Stephen Lawrence was in the middle of a securities arbitration proceeding with Bear Stearns.
Yeah. Yeah.
And it was like weeks away from a judgment.
He was 40 weeks into a 42-week...
Yeah. Exactly. He was 40 weeks into a 42-week case.
Yeah.
And 2 weeks before the judgment was entered, he transferred every penny that he had, about $7 million, into an offshore trust created by this lawyer, which was the first trust he ever did. Okay, the trust was structured in such a way that he wasn't called the protector, but as the settlor, as the creator of the trust... He
had so many retained powers.
He had retained so many powers, he had complete control over the trust.
Right.
Okay, so what happened was Bear Stearns won the arbitration proceeding, and they proceeded to try and collect the judgment. They proceeded with this supplemental proceeding, this fraudulent transfer action, and they lost.
Yeah.
Bear Stearns lost. Most people don't know. At that point, Lawrence was home free, but he didn't want to have this judgment out there hanging over him. So, clever guy that he was, he shot himself in the foot and filed a voluntary petition in bankruptcy to try and get rid of the judgment.
Oh, my God.
If he had left it alone at that point,
he'd have been home free.
He'd have been home free.
Yeah.
Okay, but he shot himself in the foot. He filed this petition in bankruptcy. And when you enter into this bankruptcy arena,
different game.
It's a whole different game. Now you're in a federal court, and a trustee in bankruptcy is appointed to administer the whole proceeding. And the job of the trustee in bankruptcy is to gather together the bankrupt's assets and pay the creditors proportionately. That's, in general terms, what it is. So in this process of gathering the assets, this trust came out. And so there was a hearing on this trust. And Lawrence was very, I'm looking for the word, he was very annoying to the judge. I can't use the real word because we're on TV here.
He wasn't a really nice guy. He really acted like a jerk.
He acted like a real jerk.
Yeah.
He was very curt and abrasive with the judge.
Pissed him off.
To the point where, okay, that's the phrase I was that's the phrase I was looking for. So he pissed off the judge, if you will, to the point where the judge struck his pleadings.
Wow.
Okay. That's as if he didn't file an answer.
Right,
okay.
right.
And what that means legally is, you know, that whatever the other side said is deemed to be correct.
Yeah.
So the other side had said Lawrence has complete control over the trust. Since Lawrence legally didn't answer that, that was the finding. He had complete control of the trust. Now you have control of an asset of the bankruptcy estate.
Right.
Turn it over to us.
Yeah.
And then Lawrence says, I can't do it.
And so the contempt followed.
Contempt followed. So that's the true story of the Lawrence case. And he ended up being in jail for many years.
Yeah.
Many years. And finally was released because of the law of civil contempt, which I will explain in 1 second.
Yeah.
Okay. He was released, but with conditions where the judge ordered the United States State Department not to issue him a passport.
Wow.
They ordered Lawrence not to leave the state of Florida.
Yeah.
Okay. Punishment enough.
Yeah.
And they ordered him to provide quarterly financial reports. But the trust is still out there, is my understanding.
And he's still living off of it.
Somehow.
Yeah.
Okay.
Yeah.
But to get to what the law is in this country, the law of civil contempt in this country has been set forth by the United States Supreme Court and has not changed since 1948.
Right.
Okay. And the law is as follows. You can't be incarcerated for failing to do something that's impossible for you to do, even if you created the impossibility. Because to incarcerate you in that circumstance would amount to punishment.
Right.
And civil contempt can't be used to punish you. It can only be used to coerce you to do something, to force you to do something.
Right.
And most people don't understand that. It's not properly argued in the cases. But that is the law in this country.
So, I mean, the moral of this story, the message is that we've had two cases where we've had any time in jail with an asset protection structure. They were both the worst possible fact.
Right.
The average client coming to us
not
today,
going to jail.
It's just not even worth discussing. I mean, it's not possible.
Right, but we do have to have this information out there and explain it to them.
Absolutely.
Okay, so this is the law.
Yeah, and there is a very big misunderstanding, and that was an excellent explanation.
Thank you. And most attorneys don't understand it either.
Yeah,
so
no, it was great.
But hopefully from this video they'll understand it.
Yeah, it was fantastic. Well, Howard, I think we did it.
Okay.
Yeah, this was fantastic.
Thank you very much, Doug, for having me on.
It was great, and as things come up, if there's anything interesting, we'll have you back and we'll talk about it.
Great.
But it's been fantastic to having you, and thank you. I learned a lot today. This is really one of my favorite sessions, and I really look forward to getting this out to everybody, because this was asset protection, not 101. This was 201 and 301. I mean, we dug into it in a deeper way than we have before. So thanks for joining me. My name is Douglas Lodmell, and this has been The Mind of Money.